Okay, so I think we'll get started. So good afternoon, everyone. Thank you for finding the time and joining our webinar today. My name is Vanessa Harrow. I'm the Trademarks Managing Director at Novagraph here in the UK. Our company is a leading international IP consultancy firm, leading the trademark representative in the EU, with the most EU trademarks and international registrations under our management at the EUIPO, as well as the WIPO. For more than 130 years, Novagraph's been supporting iconic brands and innovative organisations. We work with nationals and international businesses to ensure the protection and enforcement of their IP through trademarks, patents, designs, domain names and copyright. Our topic today is how to protect your product packaging with intellectual property, and your speaker is my colleague Mona Asghari, who's a trademark attorney here at Novagraph in the UK. Mona has extensive experience in handling all aspects of trademark clearance, prosecution, enforcement work in a variety of sectors, including food and beverages, financial services and media. She advises a variety of clients from startups to large multinationals in the UK, EU, as well as internationally. As I mentioned when the session first started, we welcome any questions you have throughout the webinar. We'll have a Q&A session at the end to answer these questions, which you can post through the dashboard. At this time, I'd like to hand over to Mona to begin our webinar.
Thank you, Vanessa. So, today we'll be looking at how you can protect your product packaging with intellectual property. Packaging is an important aspect of a company's branding strategy. As well as acting as a source of origin, product packaging can be a useful marketing tool. Protecting the look of a product is becoming increasingly important to brands, as consumers now identify some brands with certain design characteristics. So in this webinar, we'll be covering the following. How can you protect your product packaging with trademarks, designs and copyrights? How can you adapt product packaging protection, to your needs, whether you're a packaging manufacturer, a goods manufacturer or a retailer? And how can you defend your rights and prevent counterfeiters? We'll discuss the key steps to take to limit or prevent infringement of your rights. So there are several ways to protect the look of a product. As you can see, we'll be focusing on three distinctive forms of IP. That is trademarks, designs, and copyright. There is overlap. So designs can be distinguished from copyrights, which is intended to protect creative works and arises automatically. And trademarks are signs that are intended to distinguish the goods and services of one entity from another. To protect your product packaging with trademarks, designs, and copyright, there are various steps you can take. So, firstly, register your trademark. Trademarks don't just protect brand names, they can be a useful tool to protect other aspects of packaging, such as the wording used on it, or certain designs or characters. And in order to be registrable, a mark must act as a badge of origin. Once a registration is obtained, it can provide indefinite protection. Consider which elements of your brand to register. Consider the relevant territories as well as the goods and services you want to cover. A registration will give you the legal right to use your trademark exclusively in connection with your products. You can use your trademark on your product packaging to prevent others from using the same or similar mark that could confuse consumers or dilute your brand. Some jurisdictions allow common law or unfair competition rights in trademarks which haven't been registered. These protect the goodwill in a brand, including shapes, logos, colours, and so on, and also protect against unfair imitation. Trademarks and the UK law of passing off can be applied to the same facts with very different results. So one case that went all the way was the claim brought by United Biscuits against Asda stores for trademark infringement and passing off. This UK case involved two brands of chocolate bars, United Biscuits brand Penguin and Asda's own brand Puffin. So in respect of passing off, the court held that the puffin packaging and get-up were deceptively similar to those of United Biscuits' product. Although it was accepted that Asda hadn't intended to deceive the public, it had in fact done so due to a miscalculation of the degree of parody that was acceptable without the product being deceptive. As for trademark infringement, the court held that the use of the word puffin, once the surrounding matter had been disregarded, did not infringe the registered trademark penguin. So moving on to designs, one of the quickest and most effective options that's often overlooked is a design registration. A registered design gives you the exclusive right to make, use, sell, import and export any product embodying or bearing the design. A design right protects the whole or part of a product, including appearance, packaging, get-up, and so on. Essentially, designs are concerned with how objects look, not the functional aspects or how it works. For the latter, you'll need to consider a patent. So in order to meet the criteria for protection, the design must be new and have individual character. It can't be similar or be easily confused for another earlier design. Registered designs can last up to a maximum of 25 years. There are different types of unregistered design rights. So how long you're protected for depends on the type of design. The shape and configuration of a 3D object is automatically protected in the UK, whichever ends first. So either 10 years after it was first sold or 15 years after it was created. And the appearance of a product is protected in the UK for 3 years from the date which you make your design public. This is known as a supplementary unregistered design right, and it covers both 2D and 3D products. So moving on to copyright. Copyright protects a broad spectrum of original creative works, including packaging designs. Protection arises automatically as soon as the work is created. One of the main advantages of copyright is that protection lasts for a very long time, usually 70 years after the death of the author or creator of the work. Copyright can exist in various areas, such as labels, packaging, brochures, and so on. It's important, though, to consider who created the work and who owns the right. There are pros and cons for both unregistered and registered rights. Both provide the owner with exclusive rights to use a mark in the relevant territory. A trademark registration confirms legal ownership of a mark and can be used to prevent unauthorized use. A registration also can be a financial asset, which can be easily licensed, assigned, and used as security. Unregistered rights are available for marks that don't initially fulfill the initial requirements registration, but whilst they have their advantages, because they arise automatically and cost nothing, relying on them can be difficult and costly. It's often difficult to prove that copying has occurred. Element if infringement is to be established. So good protection consists of several layers. It's helpful to consider each of these by using this brand pyramid approach. A key aspect of a brand owner's strategy should be to register the various elements of their brand subject to the registration requirements of each. Consider whether the particular elements of the brand is subject to change, or whether it is considered a core and unchangeable part of the brand identity. So whilst for brands, trademarks and copyrights are core weapons against competitors and potential infringers, they often can't protect a design's look and feel. In the world of consumer goods, cheaper own brand lookalikes are commonplace. In the recent UK case before the High Court in London, Aldi stores were held to have infringed Marks & Spencer's registered designs for a range of gin-based liqueurs. So M&S launched its gin liqueur range containing gold flakes and with an LED light in the base of the bottle in autumn 2020. Aldi started selling its gin liqueur containing gold flakes in a light-up bottle in November 2021. Unsurprisingly, M&S launched its design infringement claim within weeks. So Aldi's Infusionist gin liqueur was held to amount to an infringement of protected designs for M&S's light-up gin liqueur range. So whilst Aldi had relied on the fact that its bottles had the words "The Infusionist Small Batch" on the front as a point of difference from M&S's registered designs on which no words appear, the High Court decided that Aldi's product nevertheless didn't create a sufficiently different overall impression to M&S's product. So moving on to how you can adapt your protection. The steps for protecting your product packaging can vary, and it depends on whether you're a packaging manufacturer, a goods manufacturer, or a retailer. So if you consider each of those, if you're a packaging manufacturer, you can protect your packaging with design registrations. This will give you exclusive rights to manufacture and distribute the packaging. You might also want to consider registering your company's name and logo as trademarks as well. If you're a goods manufacturer, you can protect your product packaging with trademarks, designs, and copyright. Trademarks can help you build brand recognition and prevent others from using similar marks. You can protect your packaging with design registrations, and copyright can protect any original creative elements in your packaging. And finally, if you're a retailer, you can protect your own private labels with trademarks and design registrations. This can prevent other retailers from using similar packaging or brand names. Now, defending your rights and preventing counterfeiters can be a challenging but really critical aspect of protecting your product packaging. There are some key considerations that I'm going to run through with you. So before you launch your product, conduct clearance searches to ensure that your packaging, design, trademarks, and other IP do not infringe on existing rights. Secondly, build a strong IP portfolio. This means registering your IP where you can. Consider the various layers of protection. Future-proof your protection by thinking about the possible markets that you might want to trade in the near future. Thirdly, educate your customers about how to spot counterfeit products. Provide information on your website, social media, or in your packaging about what to look out for and how to report suspicious activity. Work with law enforcement. Report any counterfeit activity to law enforcement agencies, including relevant customs officials. Provide them with information about the counterfeit products, including packaging designs, trademarks, and so on. So the market. Keep an eye on the market for products that may be using your packaging designs or trademarks without your permission. This can involve monitoring online marketplaces, retail shops, and other distribution channels. And finally, take action. If you discover infringement, consider taking legal action against the infringing party. But take a staged approach though. Pre-action measures such as cease and desist letters, negotiations, and so on are often the best and most cost-effective way to achieve the desired results. So protecting your IP can be a complex and ongoing process. There is no single way to protect every aspect of a product. The first step is to take legal advice early on to understand and identify the options available to you for protecting as many aspects of your product as possible. Maintaining effective IP protection requires you to stay vigilant and agile. You'll need to keep questioning whether new registrations are needed, whether previous registrations can be dropped, as well as staying on top of what the competition is up to. Novagraph can develop a comprehensive strategy for protecting your IP that aligns with your business goals and budget. So I'll now pass it back to Vanessa to kick off our Q&A session.
Thank you, Mona. So before we move on to the Q&A session, I just wanted to draw everyone's attention to some helpful resources that we provide here at Novagraph. Our monthly IP newsletter, Perspectives, is full of strategic guidance and updates on important industry developments. You can sign up to our newsletter via the website shown on the slide. And as Mona mentioned at the end there, maintaining and enforcing your IP portfolio is a complex and it's an ongoing process. So if you do require any IP advice following this webinar or in the future, please do not hesitate to reach out to Mona or indeed any of our experts here at Novagraph. So if we can move on to the Q&A. So we actually had a few questions received in advance, and I can see that we've had one question come in so far, as well as a nice hello from Denmark, from Ava, so hello to you. So starting off with the first question that we've received. So the question actually is referring to patents, but I think actually we can sort of extrapolate that to trademarks and design. So the question was, how do you indicate on a product that's on the market that it is patented or that it has a patent pending? How is the packaging usually marked with the patent number in the case of a granted patent, or with the application number in the case of a pending patent? So Mona, perhaps if you wanted to answer that sort of from the perspective of trademark and design protection rather than patent.
So it's important to, whenever we have a registration, clearly, label any kind of packaging that you have to indicate your registration details. So for instance, with the trademark registration, you'd put the trademark number on there. You've seen various instances of people putting C in a small circle, which indicates that it's copyrighted. Again, the same applies to patents. But also, if you're using a brand that's not a brand, that's not yet registered for whatever reason, you can use TM next to it to indicate that you're using it as a brand, to make the public aware that you're using that as a brand. And obviously then once it's registered, you can put the R in a small circle next to it to show the public that it's registered.
Well, thanks, Mara. I think just one thing to add to that as well, which I think perhaps a lot of brand owners perhaps aren't aware of, that in some jurisdictions, it's actually a criminal offence to use the R in a circle symbol if the trademark is not registered. So that's just something to be aware of, because I think a lot of people just automatically kind of put that on their product packaging or any sort of marketing material that they create for a brand. So it's important that you only use the R in a circle symbol if you actually have registered protection for the trademark. So just moving on to one of the other questions that we received in advance, also just to say if anybody does have any questions, please feel free to pop them in the question box for us. So one of our questions we received in advance, if I design packaging, who owns the copyright?
So with copyright, generally ownership vests in the author. But if you have an agreement in place, you can set out what rights the designer and the end client has. There are exceptions though, and one of those is when you create a piece of work in the course of employment. So in this situation, the employer would actually own the copyright.
Well, thank you, Mona. We've got another question that's just come in. Does copyright need to be registered in the EU to enforce?
Copyright, I mean, I can comment on in the UK aspect. Obviously, Novagraph has several offices across the EU and agents globally that can advise in separate jurisdictions. But in the UK, copyright arises automatically. So there's actually no need to register anything, it's automatic.
Yeah, and I think actually that's one of the things to keep in mind with copyright, that it arises automatically in most jurisdictions upon creation. So if you create something in the UK, that can give you copyright internationally, but in terms of actually the protection that you have and being able to enforce that will vary by jurisdiction. So if you have issues come up in a particular market, it's important to seek local advice in that particular market to make sure you understand the scope of your protection, what needs to be done to ensure you've got the right protection in place, and then what you can do to enforce that if you have any issues. So just as with trademarks, it is really jurisdictional in nature, that it's not a one size fits all across all countries. So we've got a few other questions here. So in fact, just really turning back to that point there, one of the questions here is, in which jurisdictions is it a criminal offence to use the R symbol if it isn't registered? So for instance, I know the UK and I believe the US, it's a criminal offence, but again, as I say, it's not a one size fits all. It's something that it really does depend on the market. So if that's something you're concerned about, I'd suggest reaching out to IP Advisor here at Novograph. We certainly would be able to guide you on that. Mona, have you got anything to add on that question? Is there any other jurisdictions that you're aware of?
No, I think you've covered what I would have commented on. Thank you, Vanessa.
And then we've got a question here that's come in. Would you advise registering an entire packaging as a trademark with or without the brand name on it?
I think it's always wise to do things separately, as I mentioned in like the brand pyramid, the different layers of protection, because that will give you better protection essentially. So I would do the various elements separately if possible. But I mean, again, it very much depends on what the packaging is and what the brand is and so on. So it would need to be you know, assessed on a case-by-case basis, really.
Well, thank you. I think we've got time for another question. Again, this is one we received in advance, but I think is quite an interesting one that our audience might like to hear today. So the question we received is, can you rely on both unregistered design rights and copyright?
Actually, yeah, this is an interesting one. Often there's overlap. So where a third party infringes on one of the rights, they may infringe on the other. But where both rights are applicable, UK law states that if an action for copyright infringement is available, you can't then rely on design right infringement as well. So in that case, you'd need to copyright would be the IP right that you would need to rely on.
Well, thank you, Mona. So I think we've probably got time for just one more question, which has come in. So is there any downside to use the TM symbol on trademarks that are registered in some jurisdictions and not in others, but is done to ensure that products aren't labelled with the trademark and the registered symbol if there is little control on where the trademark products are sent? So I think really sort of looking why you would use the trademark symbol rather than the registered symbol, even if the mark is registered.
So the R symbol is, you know, is if you've got a registered right, you would use the R symbol really. It's only TM if you haven't got a registration. So they have different purposes in that sense. I'm not sure if I quite caught the whole question. I'm trying to read here, but
yeah, I think just to add to that, I think in some places using the R symbol effectively puts people on notice that there is a registration, yeah, which I think in the US in particular, this is the case, that it can then have an impact on any potential infringement proceedings, not in terms of whether or not the activity is deemed to be infringing, but in terms of potential costs awards. I'm not 100% certain on that, but it's sort of from the back of my brain that's coming through as one of the things that happens if you use the R in a circle symbol. I think the other thing to just be aware of, we're talking about the criminal offence. If you use the R in a circle symbol, for instance, in the UK, and you have registered protection in the US, I believe that is not a criminal offence. You do have registered protection there. So if you're using it in a market where you don't have the registration itself, but you do have a registration for the trademark in another country, then that can provide a defence. Again, that would depend on jurisdiction, so it would have to be something that's looked at, but that's my understanding of the situation. So I think we have answered all of our questions, and we're just coming up to the end of our time there. So I just want to say thank you very much to everyone for the interesting questions that were put forward. If anybody has any questions that were unanswered, or you haven't had a chance to put them in and you think of them after the session, please feel free to send them through by email. And finally, just a big thank you from all of us at Novagraph for participating in today's webinar. Please feel free to contact us for further guidance on any of the information you've heard here today. We hope to see you again next time. Goodbye.
Goodbye. Thank you.